of economics. This is TV18 and you're watching CNBC TV18.
Presented by EY, building a better working world.
Hello and welcome to this special Eye on India, cracking the insolvency and bankruptcy code. I'm Anisha Natarajan. Finally, there seems to be some light at the end of the tunnel for resolving the 8 lakh crore troubled assets and debt. And as we speak, 222 insolvency proceedings are on in the various national company law tribunals. We know this is not an easy process. There are several challenges and pitfalls ahead for IBC to work in its true spirit. What are these and how best are insolvency professionals geared to actually resolve them? Joining me today are Abhizer Divanji, Partner and National Leader, Financial and Restructuring Services at EY India, and Sumant Patra, Insolvency Lawyer of International Repute. Gentlemen, thank you very much for joining me.
Thank you, Manish.
So, 222 cases pending. Lots of excitement that something will happen, Abhizer, but there are lots of issues as well. And I think the biggest question amongst all stakeholders' mind is, what happens in this 180 plus 90-day period to business as usual? Where does the money come from? Interim finance, capital, and who runs the company?
So it's 180 plus now 90 days, it's 270 days actually. The first 30 days really of that process is about getting a valuer appointed, getting a stake on claims, and ultimately trying to form a committee of creditors which will then take the decisions going forward. So there's an interim resolution phase, which is the first 30 days. The next phase that comes in is when people try and manage the business to some extent, stabilize the business. As I say, I don't think there's any intent or expectation of growing the business, but to stabilize the business a bit, finalize the claims, put information out within the prospective resolution providers, and invite bids from resolution providers, analyze those bids, put it forward to a committee of creditors, and take a final decision. When I talk about running the business, it also includes a very important phase of raising some interim finance.
Correct.
Such that those businesses can be held going forward. And the biggest and the unwritten rule is to manage the various insecurities that exist within the system.
Within the system. Okay. Interim finance, what are some of the challenges which are bound to come? And how will you look at it, resolving them?
One of the biggest obligations of the insolvency practitioner is to run the enterprise as a going concern. And besides that, he is also obliged to preserve and protect the value of the enterprise. Now, for doing both of these, he needs money. And if the enterprise is cash-strapped already, and obviously it is, because that is why it has gone into an insolvency, he needs to mobilize those resources from somewhere. The low-hanging fruit always would be to go to the existing set of lenders to say, put me into some money. I mean, that could be basically new money or the money that is already being generated.
Will
but
lenders give, is a question.
Well, I mean, yes, I mean, it's a cultural issue. I mean, I think lenders are always reluctant to put, good money out of that, after bad money. Their concern is that, we already are, stressed out, so why would you expect us to put in more? But the reality of the life is that, you can't continue to run the business and preserve the value of the business without some cash in hand. And the challenge is that, all this is being done at the end of the day to maximize the returns for the creditors. So they need to understand that if the money is being asked, it is to preserve the value of the enterprise so that the creditors at the end of the day can maximize their returns through the resolution process. So it is in their interest more than anybody else's.
My question is, are they understanding it? I mean, what you said, you started out with your answer saying that there is so much insecurity, right? So will lenders understand this? Are lenders understanding this? Because several of them we have now some examples of actual cases.
So I think one thing is it's a matter of communication. As I said, insecurities. Let's just focus on that. There is a huge level of lender insecurity, and the law provides for it. Law says, and the lender insecurity is, that I will end up losing my good security for money coming in, which may go in for a bad business.
Right.
And that's the real insecurity one has to deal with. And how do you cover that? is that to prove to somebody that the enterprise value that will emerge after this interim finance, the lenders would be better off in terms of their expected return.
You have a case like Innoventive now where hardly any value is left. So what do you do?
So Manisha, in Innoventive, or the second case, are aberrations. First of all, they are small.
So,
right?
so this message needs to go out.
No, absolutely. So that is going out. At least we are doing our job and bankers are understanding. But the thing is that, see, these are aberrations. You've got to understand that. Why are they aberrations? Because these are the small scale businesses. Talk about the larger ones, which own significant part of the country's assets, employ a significant number of people.
The 12 big cases which have 25% of
There are companies in this 12 who have 3,000 crore EBITDAs, even today. Why would they not have interim financing?
All right.
We're not talking about a company which is completely strapped and no revenues.
Okay. All right.
And one point that I wanted to make, Manish, was that, a lot of people, a lot of the lenders are not appreciating that interim finance actually gets repaid as the cost of insolvency resolution process in priority ahead of everybody else's payments. So they are protected, they are insulated, in fact, and from that point of view, and their interest is ring fenced. But yes, of course, one of the concerns that they have is that if the company goes into liquidation, then their interest on the interim finance stops running. But that's what the law says. To that extent, yes, their concerns may be a little valid, because in other jurisdictions around the world, like for example in Singapore, the interest on the interim finance payments continues to run even for 1 year after the liquidation order is passed. And thereafter also the insolvency professional, by whatever name called, can actually extend it for another period of time at whatever rate of interest he considers appropriate. That only is the reason why you incentivize distressed asset funds, special situation funds, and existing lenders to come forward, right? So, but that I think is a correction that can be made going forward, but there's enough.
There's so many which have already been made since January.
So
right?
there's enough, I think, comfort available within the law for the lenders to be incentivized, and I'm hoping that going forward they would recognize and they would come forward more willingly as against now.
All right. Let's come to IPs per se. Do they really have the bandwidth to run such complicated businesses, metal, mining, construction, Abhizer, or do they need a lot more backing? I know legally they are protected, but do they also have the courage to take tough decisions? The two questions.
Let me start. There are 900 IPs in this country. The 200 cases filed. So of course there is no threat of IPs. I think there is a threat of.
But an individual running or thinking through such complicated large businesses.
So the law says that an individual is appointed as an IP, and that's right, because that's, I think, a global principle also, because you need to fix accountability. That's fine. The second issue is whether that person can garner the level of support. So if you look at the 12 cases that have been, the bankers themselves have chosen people who are supported by platforms. And those platforms actually provide the skills. So clearly, I think
and I think this is a message which needs to go out, that these are not individual professionals who are going to be running the companies, right?
And very typically, I think then we need more domestic platforms to be built. People who have operational expertise, who have sector expertise, who have financial expertise, coming together and forming these platforms. The law provides for something called an insolvency professional agency, an entity. Let that be formed. And let their people come in and actually pool in interests, and then they'll create platforms. So I think what we have is a dearth of platforms, not of IPs.
All right. No dearth of IPs. However, do you think that legally they have the protection to take tough decisions?
Well, I think the intent of the law was to give them sufficient powers, to give them sufficient bandwidth within the legal regime to be able to perform their duties effectively. Now, it all depends on how an individual perceives those provisions. Some are very timid and conservative and read the law to be restrictive rather than being liberal and enabling. But there are others who basically use these languages to say, no, this is my duty is to run the enterprise as a going concern and to protect the value. So therefore, I will read the entire law in that spirit, and which means that I have to ensure that I fulfill these two obligations. And once you understand the concept of insolvency, then you would not be hesitant at all in your approach. So therefore, in my opinion, till such time the resolution plan is presented, it is a completely full-fledged loaded powers for the IPs if they want to do it. But there is a corresponding responsibility that comes with it. This protection that we talk about is against things that may not have been done in good faith. Their protections are only about good faith. If you are being if you indulge in anything which you cannot later on convince the stakeholders that you have done in good faith, then something will come back to bite you.
Of course.
So you have to, so you are accountable. So it's not that you are not accountable, and you are, and I think you should be more accountable than anything else. You have to, at the end of the day, you are a trustee of not just the law, but also of the assets on behalf of the enterprise. So therefore, it is a very onerous responsibility.
Overall, I mean, what are you hoping that IBC will deliver in 9 months? There's such high expectations. Of course, it's that big stake. It's a time-bound process. It's an expensive process. So will it deliver?
Well, I think it will. It has been, and I believe that one of the challenges, of course, is that the government decided to give IBC a jump start by bringing in such high-profile cases involving so much of assets of the country, into insolvency right at the beginning of the implementation of the law. That, of course, also adds to the cost because there are uncertainties.
Right.
It's, you're charting, basically going to uncharted territory. And obviously that means that people will take advice. There will be all kind of issues. I still feel that IBC has lived up to the expectations of the policymakers and professionals like us,
I would have to agree to that.
Yes,
There's
that's right.
so much positive
That's
hope
right.
now.
That's right. And I think it will continue to be as long as all the stakeholders continue to have their learning at the same pace, and the government and the IBBI in particular as the regulators stay ahead of the market in terms of identifying their needs, identifying the gaps in the law and plugging them as we go along.
All right.
And once that is happening,
So
I think everything will be in place. Yeah.
I think you have to just keep adapting, keep evolving, and keep changing.
I have two
Very
indicators
quickly.
which I will
Yes.
measure the success of IBC. One is, let the promoters churn if they have to. But ultimately, if average promoter holding in our country comes down from 80% down to 35 to 40%, I think that will instill a lot more governance in the system.
That's a simple yardstick.
Well, but that has to
It's a hard one to achieve, but it's a simple yardstick.
And I'm indifferent whether an existing promoter comes in or a new promoter comes in.
in.
General promoter shareholding needs to go down to 35-40%, and the balance held by institutions. I see proxy firms, etc., playing a much larger role in bringing in governance because of these guys. That's one. And secondly, I think what people are looking for, and the intent was to get the bond markets running. And I think if we have an efficient legal system, which NCLT has done a fantastic job until now, but if we continue doing that, and the creditors, apart from the banking system, have a go-to in case of default, I think we'll
be there.
Absolutely.
Time for a short break. When we come back, we move to decoding Supreme Court stay on JP Infra Insolvency Order of August 9th. What does it mean for all stakeholders, buyers, insolvency professional, IDBI Bank and JP Management?
Introducing Mac 40 Next with advanced synthetic technology. Maximum riding comfort. Maximum power. Environment friendly. Longer engine life. Mac 40 Next with advanced synthetic technology from Bharat Petroleum.
Look, idhar, आगे सर, उधर, इधर, लुक्का छुपी, कोई तो बचा ले यार, कहीं तो छिपा ले यार, लुक्का छुपी,
अरे इनके घर को डर कैसा? इंडिया में पहली बार एक्सेल माइका मार्बल, माइका पेंट को बनाए टफ और मार्बल उसकी शान बनाए रखे सालों साल। नेरोलैक एक्सेल माइका मार्बल, टफ भी शान भी।
नेरोलैक।
Setting is everything.
Setting is everything.
Introducing Lines by D-Deco, because setting the mood is everything.
From identifying the movers and shakers of the week to spotting new trends as they develop, we get you all the buzz in the commodity market and help you connect commodity to the company. Let the biggest champions guide your investments and find out on what to expect in the week ahead.
The Commodity Champions. At these times. Only on CNBC TV 18.
Commodity Champions, brought to you by Nakshatra Diamond Jewelry.
Class, speed, raw power, max torque. Get ready for an unmatched automotive experience. Servo presents Overdrive.
Overdrive, presented by Servo, world-class lubricants from Indian Oil.
First time home buyer. Only on CNBC TV 18.
In a twist to insolvency proceedings in JP Infra case, the Supreme Court has stayed the order of the National Company Law Tribunal (NCLT) of August 9th, filed by IDBI Bank for insolvency. The order had actually approved the appointment also of an interim resolution professional who was tasked to revive the company within 6 months. While this is being spoken about as a big relief to 40,000 homebuyers stuck in severely delayed JP Infra projects, is that really so? Sumant Batra, the IRP professional and lawyer, is with us. So let me first ask you, the stay, does it mean that Mr. Jain has to shut shop and the management and the board is back in the saddle?
Well, yes. To answer the first part of your question, yes, the IRP can't act any further on this because the order appointing him as the interim resolution professional has been stayed. Now, as regard whether the status quo ante is restored, which means that the board of directors that was suspended comes back into place, and whether the management which came to be vested with Mr. Anuj Jain goes back to the erstwhile people, well, that is something which I'd leave open. Although one would argue in his favor. So
no absolute clarity there, but I mean, it's a natural or logical conclusion of the stay.
True.
All right. The nervousness that the buyers had was basically coming from, Mr. Batra, the fact that they had absolutely no clue about their rights. Whether it was a finance minister, or it was Mr. Jain himself, or it was any other person in power, they were refusing to tell or give the buyers this assurance that nothing will happen to their homes. They will not lose their property. Do you think that it could have been salvaged if at all just that statement had gone out to the buyers?
Well, I don't really think so, because I think, speaking for the IRP, I think he did a fairly good job in reaching out to these stakeholders through the FAQs, through the press release, to assure them that he's mindful of their interest. He kept them informed of as to how the claims have to be filed, answer their various queries. I think he did a fairly good job. As far as the government is concerned, I don't think it's the job of the government to actually interfere in the process. The process itself is actually something which gives them sufficient amount of room in order for their interest to be...
Is there room? Well, is there room? Because if you look at the code per se, really, it was not made for a B2C business, which everyone has accepted. We have spoken about it. A separate form was introduced, but essentially, what was their status? What was the buyer status? There was a, committee meeting, which was COC meeting, which had been scheduled for next week. Of course, it will not happen. But buyers had not got an invite for that as well.
Well, buyers are not supposed to be invited to the meeting of creditors, but so let me step back a little bit. You see, we have to understand that insolvency code is not a detailed statute. I mean, like any other decent insolvency law, it is a procedure-based law. It is a regulation-based law. It is a best practices-based law. So within those best practices, I would read that there was room for them to be consulted, kept informed and engaged. I mean, that stage never really arose. I mean, I think we still had to see that stage. But having said that, yes, because it is not written there in black and white, it is natural for such a large number of people to feel anxious and to be discontent about the fact that they are not, inclusive in terms of how the process is happening.
Their fears were valid. At some level, they were valid. Okay.
I wouldn't just brush aside that concern of theirs.
Concern completely.
Yeah.
All right. Now, what happens? Supreme Court has also issued notice to JP, the Finance Ministry, the Reserve Bank of India, UP government, right? Corporate Affairs, IDBI Bank. What is the meaning of that? What are all of these people meant to come back to Supreme Court with?
Well, you see, they are the key stakeholders in the whole insolvency system, and some of them more particular to this case in hand. So therefore, obviously, the Honorable Supreme Court would want to hear all the stakeholders in order to be able to decide the petitions that have been brought before them. All of them, or to the extent the relevant stakeholders, will file their reply, and the Honorable Supreme Court will hear them out as we go forward. And as we already know from today, that the IDBI has already mentioned the matter before the Supreme Court, requesting for a modification of the order, and the Honorable Supreme Court has now posted the matter for 11th, that is Monday, and requested IDBI to file an application if they choose to the extent of the modification that they seek.
All right. Could IDBI have given an undertaking? Do you think they were, as a party, could have given an undertaking that the buyer's interests would be protected?
Well, I can't speak for IDBI, of course. It is for them to decide.
Within the framework of the law.
I don't even think that an undertaking is required, and neither can anybody give that undertaking, because there's a law, there is a process, and everything has to take place as per that process. But I personally believe that the law is wide and broad enough to absorb the interest of those stakeholders, and the creditors who are supposed to pass this by 75% voting share wouldn't have sanctioned a plan which did not take care of the interest of these large body of stakeholders. At the end of the day, they sit at the core of the JP's business. So how can you sort of exclude them from the resolution plan?
Okay. Wear your lawyer's cap and tell me, this one other big concern that the buyers had was that the Section 14 moratorium now is gone, and they can continue to fight their cases in NCDRC and even go to RERA. Is that a big relief for them?
Well, it's a double-edged sword. I mean, it is easy to say that, allow me to go to other forums. But I would say that, what the insolvency law actually offers is an opportunity that all these kind of claims can actually be settled in one proceeding and in a very speedy manner. So I would have preferred that the flat buyers actually expect that the resolution professional will find a solution.
They have lost some time on this. Let's see what happens when IDBI's application is heard.
It may not be fair for me to say whether they've lost or not. I mean, the Honorable Supreme Court will decide that eventuality, but
I said lost time. If nothing else, they've lost some time.
Well, yes, I mean, certainly yes. I mean, the fact is that, the insolvency process, 180 days, and Anuj was moving at a very good speed. I mean, we had made very significant progress from that point of view. But having said that, individuals are entitled to make their own choices, and we can't
dispute with that, and that's what Chitra Sharma did. In fact, even as PILs go, there were two groups, and they both had a difference of opinion. Very quickly now, this has also opened up a Pandora's box. There is Amrapali, which is now in front of NCLT. Nothing stopping the buyers of Amrapali to go in front of Supreme Court as well, is there?
Yeah, for that matter, of any other real estate
even
insolvency.
Even a B2B business? Because they would also have some level of buyers. Is it a larger big issue with IBC?
One may not go that far, but certainly because one sector, real estate sector, major insolvency is now before the Honorable Supreme Court. So others who in the real estate sector were in insolvency or on the verge of insolvency obviously would want to sort of be associated with this case to see how the outcome affects them. So I think that's quite natural.
Okay. What is the best case scenario? I mean, again, as an independent consultant and an expert, you've been privy to what JP management has gone through. You've also been in NCRC in the distress of the buyers. What is the best case scenario? Let's say Monday hearing happens, or even the October 10th hearing happens, what is the best resolution possible in this case? Because IDBI does not want the management back.
Right. So I don't know. I haven't spoken to IDBI, so I cannot say what they want. We will know it on
from a buyer's perspective.
Yeah, from the 11th. I mean, what I can say is that from all stakeholders' perspective, not just the buyers.
Okay.
Insolvency process is perhaps one of the most effective and efficacious mechanism available to resolve a distress situation. We couldn't have really had a better law than this. There may be some cracks in the law, but those can be mended. So I still feel that eventually it will all come down to this process, perhaps with the concerns of some stakeholders being addressed by the Honorable Supreme Court.
Some stakeholders, I think, is the buyer stakeholders. They definitely need to hear from the Supreme Court some sort of safeguards for the buyers built in. You know, it was all spoken about, like you said, Anuj, and kept referring to it, but there was really no statement because he couldn't. He had to still speak within the framework of the rules, and the rules were not made for B2C business.
Absolutely, and you have to appreciate even now, you know, Anuj is just an officer of the court. He will follow the instructions of the Honorable Court. He is there neither to defend or the contest the order. He was appointed by court and he has been stopped by the court, so he would follow the instructions in letter and spirit of the Honorable Court.
Gentlemen, thank you so much for joining me. Well, borrowing from that report, there is really no perfect world or a perfect solution, so neither can we hope to get a perfect code to crack India's distressed asset problem in one shot. What we can definitely hope for is that stakeholders will be flexible, open-minded, including buyers, and adapt to ensure that this code actually works. Goodbye and thanks so much for watching.
Presented by EY, building a better working world.
फाइनली शॉपिंग खत्म।
ये देखा तुमने?
होम लोन पे 12 EMI ऑफ, पर अभी हमें क्या जरूरत है?
शादी अभी ही तो है।
तो
शुरू में सभी खुशी से रहेंगे, फिर ड्रामा शुरू, माँ की या बीवी की। इसलिए अभी माँ की सुनो, नया घर ले लो।
आपसे दूर,
घर आसपास ही लेना।
होम लोन्स पे 12 EMIs off from Axis Bank. Most racers try hard, but one has learned to hug every curve. New Gillette with flexible technology. 5 blades for an effortless shave. Now save up to 15% on large packs of Gillette cartridges.
What is money? How much money should a nation create?